Welcome to the lecture on confidentiality and consent. We're going to talk about what confidentiality means, what do social work professionals need to know about it, and why does it matter? So there are three main aspects of confidentiality. Confidentiality as a norm of professional behavior, privileged communication, and confidentiality as that is regulated by statute. Confidentiality in professional ethics. It's required by the NASW. It's in the Code of Ethics. There are enforcement and sanctions through professional associations, and there are also legal protections and implications. These are outlined in the NASW Code of Ethics. Now, privileged communication. The information is privileged and belongs to the client, not the practitioner. It's regulated by state statutes. There is a wall of privilege that varies by profession and across states. It's associated with professional licensing, and some exceptions exist where it is malpractice not to disclose. So what are some exceptions to client privilege? So by statute and case law, if there's knowledge of child abuse, if there's a credible threat to the self or to another. There was a legal case in California, Tarasoff, where the findings led to the development of duty to warn. And this is now a legal principle codified in many state statutes. Exercise of privilege does require consent. So when questions of disclosure arise, the client must give informed consent or no consent. So who's capable of providing consent? We have to think about this within the context of age, right? Developmentally, are they at a point where they can cognitively understand and make these decisions appropriately? Within the context of mental status as well, how does that affect their understanding and experience of these essentially verbal contracts? Provisions for decision-making when one is incapacitated. So some examples of this would be advanced directives. Guardianship would be another type. So consent and confidentiality for minors. Parents of minors are generally assumed to have the power of consent and full access to information about the child, but at some age, minors may have consent power for medical treatment, and exceptional circumstances may justify refusal to disclose information to parents, especially if it could create harm for the student or the child. Disclosure of information for minors has become an issue for school social workers. However, we don't currently have a clean and consistent resolution. Now, confidentiality for deaf persons and others who require interpreters. For persons who communicate through an interpreter, some questions have arisen about the impact on the therapeutic relationship. Also, there's concerns about accuracy of the interpretation, and confidentiality is considered to be extended through the interpreter. That is the expectation. Now, confidentiality from statute. So this is going to be legislation or regulation mandating the confidentiality of treatment information. And some examples of this would include state licensing laws like state practice licensing, defines confidentiality and privilege, state mandatory reporting laws. You also have state health or treatment laws like HIV/AIDS test information. There's federal law like HIPAA, the Health Insurance Portability and Accountability Act, and then federal regulations like substance abuse treatment confidentiality. Now the new MHL 9.46, this is included in the SAFE Act. A mental health professional must report person who is likely to engage in conduct that would result in serious harm to self or others to the County Director of Community Services or designee as soon as practicable. If the Director of Community Services or designee agrees that the person is likely to engage in such conduct, he or she fills out and submits a secure online form to the New York State Division of Criminal Justice Services. The DCJS determines if the subject of report has or has applied for a firearms license or has registered an assault weapon and works with state police, which notifies the appropriate county firearms licensing official. The county licensing official must suspend or revoke the license as soon as practicable. Licensing official notifies law enforcement to remove the gun. Now, some federal confidentiality statutes: HIPAA, the one you're likely most familiar with, the Health Insurance Portability and Accountability Act. It's privacy for protected health information. It requires patient permission for disclosures, exceptions for payment, treatment, research, and public health. Confidentiality of alcohol and drug abuse patient records. Part 2 has strict rules for handling of information about AOD treatment. And the Supreme Court case, not a statute, of Jaffe versus Redmond, established a psychotherapist privilege in federal courts. HIPAA, the privacy rule for protected health information. So protected health information is identifiable health information acquired in the course of serving patients. Any of the following data make health information, quote unquote, identifiable. Some obvious ones: name, social security number, a street or email address, telephone, fax numbers, relative names, account numbers, birth or death dates, fingerprints, photographs, certificates or license numbers. Some less obvious ones would be an employer, a date of service, voice recordings. But then you can also consider any other linked number, code, or characteristic. In the medical world, to some degree, DNA evidence has been a concern. Public good uses and disclosures. So an agency may use or disclose public health information without the written authorization of the individual in the situations listed below. You've got uses and disclosures required by law, those for public health activities, those where the disclosures are about victims of abuse, neglect, or domestic violence. If it's for health oversight activities, for judicial and administrative proceedings, for law enforcement purposes, about decedents like coroners and funeral directors, uses and disclosures for cadaveric organ, eye, or tissue donation purposes, for research purposes, to avert a serious threat to health or safety, and for specialized government functions like military and veterans activities, national security and intelligence activities, so forth. And then lastly, for workers' compensation. Now, federal confidentiality of records for alcohol and other drug treatment. Some federal regulations like CFR Title 42, Part 2, under the Public Health Service Act. It restricts disclosure and use of information about individuals in federally assisted drug or alcohol abuse treatment programs. It restricts use of patient identifying information that indicates person is receiving, has received, or has applied for substance abuse treatment, and persons who have lawfully received such information may not redisclose without consent. Electronic health records and confidentiality. So part of the 2009 stimulus legislation included a mandate for electronic health records. It was the Health Information Technology for Economic and Clinical Health. ACA includes incentives for integrating physical and behavioral health. Many states, including New York State, are moving all persons on Medicaid into health homes. Providers must be aware of how data are shared in an electronic health record system and privacy levels of psychotherapy notes and records. Policy issues for teletherapy and other electronic therapy methods. And this is interesting because it's become a much larger phenomenon in recent days given the pandemic. So through use of the internet, Skype, and other electronic communication, and that's kind of broad. You can, like electronic communication, some forms are even text messages. Client and therapist may be in different physical locations, perhaps different states, but licensing generally defines where they're supposed to be practicing. Improved access for underserved areas, persons unable to travel, or persons more willing to participate in therapy via these means. Some policy concerns, and the resolutions are currently evolving. So for example, confidentiality of the client's setting, security of the electronic connection, and with the recent Zoom bombings of people being able to hack into meetings and so forth, it's a justifiable concern. and then provider licensing requirements, as I mentioned before, especially across state lines.